Lords, in a case brought second appeal number 85 of 2020, Lords, house property is there, and appeal has already been admitted. Stay in application is already there. Therefore, this
रिकॉर्ड आ गया
LCR तो कॉल हुआ है.
आप चेक करिए ना, बिना चेक किए भी बोलिए, इंस्पेक्शन करके चेक कर लीजिए, स्टेटस पता कर लीजिए.
लेकिन हुजूर इसमें 15 तारीख को ही लास्ट डेट
तो
रखा है.
आप 15 तारीख
इसलिए इसको रखा जाए. इसको किसी
नहीं, आप पहले रिकॉर्ड चेक करिए. अब इंस्पेक्शन करके
इंस्पेक्शन में तो हुजूर यहाँ लग जाता है 8 दिन. अभी का जो अनुभव है हम लोगों का, जैसे अभी का जो अनुभव है,
From supplementary it is for hearing under order 41/11 item 4 second to
या
26
स्लिप देंगे तो भी रिकॉर्ड आ जाएगा. इंस्पेक्शन में आधा घंटा नहीं लगेगा.
My lord, may I mention a matter from the list, my lordship, agency said that's one, my lord. With all apologies, my lord. Your lordship
इसको
has
इस वीक में चढ़ा देने का
Item
इंतजाम
number
किया.
तो ऐसे नहीं होता.
I would be obliged. That's it.
item number 23, my lord, second appeal 153/2018. Your lordship has passed a order. Never I have got a consent from my learned senior friend. You have passed the order, my lord, but the agency says
ऑर्डर व्हाट ऑर्डर है आपके
I asked for consent. They have not given consent. Your lordship passed the order. जब भी ये केस लगेगा, they'll neither I nor they'll be given time. But the agency is now, my lord, writ of delivery position has been issued. I have won the title suit, and the only substantial question of law is 2197, my lord. It's 2104. That if that the order of 2197 is subject to the order of 2104, the title suit. I won the title suit by in spite of that, my lord. The writ of delivery position is. I'm just requesting, my lord, if not today, tomorrow in supplementary list, my lord.
Where is the respondent? Call the respondent.
No, they are not giving consent.
You give it in writing that they are not giving consent.
Yes, my lord, I'm giving.
रिफ्यूज आप हमको दीजिए, रिफ्यूज करा के लेके आइए.
Refuse.
हाँ, जाइए मैडम मंजूश्री पात्रा के पास, शी इज द एडवोकेट ऑन रिकॉर्ड.
And
ठीक है, उनसे आप रिफ्यूजल ले लीजिए और कल हम सुनेंगे.
Can I
लेकिन
give it-
रिफ्यूजल आपको उसके बिना नहीं होगा, बिना रिफ्यूजल के नहीं होगा.
okay.
अब रिफ्यूजल लेके आइए दैट शी इज नॉट रेडी टू आर्ग्यू दिस केस टुडे.
And if she doesn't sign, my lord, then I'm.
शी मे नॉट साइन. आपकी बात को हम मानेंगे ना, लेकिन आप उनसे पहले कांटेक्ट कर लीजिए.
Even
झूठ
I'll
मत बोलिएगा.
even I'll give a WhatsApp also. Both I'll do.
आप हाँ, आप करके लेके.
Tomorrow morning I'll mention.
टुमारो नहीं, आज ही आप उनको बताएंगे तो कल रहें, नहीं तो फिर ये तो चला जाएगा अगला वीक.
At the time of recess, can I
हाँ,
mention?
yes. You ask her that I remember कि हम लोग बोले थे कि आप इसको मेंशन कर लेंगे, क्योंकि लास्ट टाइम उन्हीं के इंस्टेंस पे टाइम हुआ था. They cannot run away from the court in this matter.
May please, your lordship. This is my lords, the defendant second appeal.
सर देखिए, यहाँ पे मेंशनिंग का सिस्टम नहीं है. मेंशनिंग हमारे कोर्ट मास्टर के पास होता है.
Mention
सुबह
item
सुबह जो
four.
है ना,
Mentioning me.
ये कौन सा
First.
item 4
कॉल आउट किए हैं?
जी.
हाँ.
I'm sorry.
नहीं, हमको लग रहा है मेंशन.
नहीं, mentioning.
All mentioning are to be allowed except specific order for rejection. और यहाँ मेंशन कोई करते हैं तो हमको फिर हम अपने हिसाब से करेंगे. ठीक है, चलिए.
Lordship. This is lordship, the defendant second appeal against the judgment of appellant. In this case, my lord will find that, my lord, the plaintiffs filed eviction suit, my lord, for ejectment of the defendant from the suit premises on the ground of default in making payment of rent and personal necessity under the provision, my lord, contained in section 11(1)(c) and D of the Bihar Building Lease Rent and Eviction Control Act 1982. Now, lordship may kindly see. Earlier, my lord, the plaintiffs filed eviction title suit number 8 of 1987.
Eviction title.
I am sorry, eviction suit number 155, 157, 158 and 171 of 1960 against the defendant, praying therein, my lord.
4 suits
Yes.
against the
Four-
same defendant.
No, against 4 showrooms, lord.
No, we don't bother about it. We
Law.
just talk about your case.
Yes.
That which was your corresponding title suit?
Title suit, lordship.
Yes.
I am giving lordship. Then lordship, suit was filed by the plaintiff against the defendant, praying therein a decree, my lord, of eviction on the ground of default in making payment of rent, which was decreed. Against that, my lord, the defendant preferred appeal before the honorable court.
Yes, what happened in appeal? How is it related to the case of 1960?
Thereafter,
How
again,
is this case related to the case of title suit of 1960?
because, my lord, similar issue in the earlier eviction suit, there was similar ground lordship,
Default was reserved for some other period.
other period.
So,
That is their lordship.
then-
That is there. Thereafter, my lord.
How will it act as res judicata in any
No,
manner?
I am not. Lordship,
You see,
arguing on the
it is
issue of
every day, every month there can be a default.
lordship. Now,
So
lordship,
how do you
may
link it to the earlier suit?
now lordship may kindly see. In the present suit, the plaintiffs have claimed eviction, my lord, on the ground of default of in payment of rent from September 1972, and claimed, my lord, the fair rent fixed by the house rent control.
Just a moment.
Lordship,
When was the suit filed?
suit lordship, (9 of 1987).
1987. Okay. When was this fair rent fixed?
Rent fixed lordship by terms of order dated 24/6/1985.
Was it passed after hearing you?
Lordship.
So, you defaulted even after 24/6/1985?
No. Now lordship may kindly see. The defendant, my lord, went on remitting the rent to the plaintiff from September 1972 onwards. Lordship may kindly see the
You forget about September.
money order
You
coupon,
see,
my lord,
you
has
forget
already
about
been.
September 1972. Any consecutive 2 months default is sufficient to decree the suit. You forget about September 1972.
The defendant
Yes,
went on depositing, my lord, went on remitting rent, but
For the
plaintiff-
period from 9/87 till the date of filing of the suit also. From
Lordship,
the,
lordship may kindly see.
what
And
about?
lordship may kindly see.
Did you make payment as per the fair rent fixed?
Yes,
not?
lordship may kindly see.
Is there any finding to that?
The trial court, my lord, came to a specific finding that in the present case, the last paid rent is ₹50 per month shall be deemed to be fair rent and not the fair rent fixed by the controller.
How
Lordship
such a
may
finding
kindly-
can be recorded?
This is the finding of the trial.
Maybe, but what is the basis of such a finding?
Lordship may kindly see. Because the
And what
fair,
happened in the first appellate court? First appellate court has concurred with this finding.
yes. Now lordship may kindly see.
What was the date of fair rent fixed?
Because
What
the
was the
fair,
rate fixed? What
Date?
was the rate fixed?
24/6/1985.
What was the rate?
Rate lordship ₹4 412.50 paise per month.
412.50 paise
Per month.
per month.
Lordship.
This happened in 1985.
Lordship.
This order attained finality or it was challenged and then what
Challenged.
happened? It was challenged.
Lordship.
It ultimately attained finality.
Lordship.
Let us see the finding on default. Read the trial court judgment.
Lordship.
And the issue string.
Lordship may kindly see page 30. Page 30.
Issue number 5.
Issue number.
Five and 6. What is the breach of terms of tenancy? Only in terms of rent or there is other breach?
No, need.
So issue number 5 and 6.
Lordship.
Where is the finding?
Issue number 5, my lord, has been dealt with by the learned trial court in para 7. There is no denial of the relationship of landlord and tenant. Now, lordship may kindly see page 30. Of the trial court.
The suit was filed in 1987.
1980.
How do you say that the fair rent proceeding was pending? Because the fair rent was fixed on 24/6/1980. How do you say that the fair rent proceeding was pending?
Thereafter, my lord, against that order, writ petition was
So,
filed.
writ petition does not, it is merely because a writ petition has been filed, the fair rent proceeding was pending. Was there any stay in the writ court?
No,
Then, how does the court comes to a finding? That it will be deemed to be ₹50 per month? On what basis? Show me some law. So admittedly you have been paying rent at the rate of ₹50, irrespective of the fair rent fixation at ₹412.5.
Yes.
How do you justify this?
My submission is, my lord, that this is the finding recorded by the learned trial court,
That's right.
which has not been challenged by the plaintiff by filing cross appeal.
What is the finding by the learned first appellate court?
Lordship may kindly see issue number 5, which has been dealt in para 8.
Or the appellate court judgment?
Lordship.
Page number?
Page number 90. It has further been stated by way of amendment in the claim that fair rent of suit premises was determined by the controller at the rate of ₹1.25 per square feet, and this rent has also not been paid, and as such on this account defendants are defaulters. According to the case of the defendants, monthly rent were always tendered, and on refusal to receive thereafter same have been regularly and continuously remitted through postal order which had been persistently refused by the plaintiff. Thus, defendants have all along been depositing monthly rent of the suit premises as directed by the municipal branch in whose court earlier suit for eviction was pending. That since after return of the claim, these defendants have been regularly remitting monthly rent of the suit premises to the plaintiff, which has been regularly refused by the plaintiff. That during pendency of the eviction suit in the court of the municipality, plaintiff filed case for fixation of fair rent with respect to the suit premises, in which controller fixed fair rent of the tenanted premises, against which both the parties preferred appeals against order of the controller before the DC Ranchi Again, order passed by the DC Ranchi, the matter was challenged before the Honorable High Court and its jurisdiction for appropriate remedy. Therefore, order passed by the DC is not final and thus defendant cannot be held defaulters under the law. It is admitted fact that the monthly rent of each shop or unit was ₹50 in all the suits, and rent controller has fixed rent at the rate of ₹1,125 per square feet on 24/6/1985 as per Exhibit 677/1/7/2. Read petition filed by the tenants challenging the same were dismissed, while order dated 5/4/1989 passed by the Honorable Court, that is Exhibit 828/3. Learned lower court observed that present suit has been filed in the Court of Subject on 20th of April 1987 after return of the plaintiff from the Munsi branch. Therefore, rent fixation case was pending on the date of the institution of the present suit. Because these petitions were pending in the High Court, challenging rent fixation order, and the same has been decided after institution of the present suit. Learned lower court has found and held that in the present case, last paid ₹50 for each unit shop deemed to be fair rent and not fair rent fixed by the controller. Section 11A of the BBC Act provides, notwithstanding anything contained in any contract or law to the contrary, but subject to the provisions of the Industrial Disputes Act and to those of Section 18, where a tenant is in possession of any building, he shall not be liable to eviction therefrom, except in execution of a decree passed by the court on one or more of the following grounds, where the amount of 2 months' rent lawfully payable by the tenant. This is Milord Section 11(1)(d). Learned lower court on the basis of Exhibit 9, agreement for lease, dated 27/7/1945 between the original owners of premises and partners of Princess Sports and Exhibit 716, later written on behalf of the landlords in connection with eviction suit number 8 of 87, held that defendant was liable to pay rent by 10th of April. Further, it transpires from this exhibit that this lease was for a period of 6 months, but it was agreed that if the lessee are permitted to remain in occupation of the premises after expiry of the period of 6 months, they shall held and occupy the same as tenants from month to month on the same terms and covenants as in this present.
You will come to page number 40. You have been held defaulter on the ground that you have not paid the fair rent as fixed by the fair rent controller. Tell us how this finding is perverse. Admittedly, you did not remit rent at the rate fixed by the fair rent.
Lordship.
So
That is
default हो गया और क्या चाहिए आपको?
But Milord, the trial court recorded a specific finding
Yes.
that Milord, the defendant is required to pay last rent at the rate of ₹50 per month.
Perverse.
These-
That finding is perverse.
But this order, Milord, was not challenged by the plaintiff by
Need not
filing cross appeal
Need not
as
be.
required under order 41
Need not
22
be.
CPC.
Need not be.
This is my submission, Lord.
We'll take care of it. What else?
And Milord, the defendant went on remitting the rent to the plaintiff through money order, Lordship, and money order coupon has been exhibited. But it has
That has also not been properly proved.
now, Lordship, it has already been proved.
How?
But Lordship,
Who has proved it?
Lordship may kindly see the
Who
finding.
has proved the remittance of
Lordship,
rent?
once it has been exhibited, Lordship may kindly see.
Exhibition amounts to proof.
Lordship, it has already been exhibited and the court, Lordship, recorded a finding, Lordship may kindly see. Only on this ground, Lordship may kindly see for a minute. This is not a case, Lord, that the defendants have not deposited the rent to the plaintiff. Now, Lordship may kindly see. page 38, Lordship Member. This is with respect to eviction case number 9 of 87.
What was your eviction case number? 9 of
9.
Read it, please.
With regard to title eviction case number 9 of 87 as per exhibit 9 by 8, lease between the original landlord and the original tenants, the monthly rent was payable by the 7th of every month. Initially, lease was for 6 months, but it was agreed in it if the tenants remain and continue in possession, then the tenancy will be month to month and both the parties shall abide by the condition of this lease. On behalf of the defendant to show that there was no default and monthly rent was regularly paid through money order, marked exhibit G to exhibit G/164 and money order coupons exhibit F to exhibit F/281. Now
आगे
Lordship
पढ़िए, please.
may kindly see the finding. There is large difference between number of money order receipts and money order coupons. For each money order coupons, postal receipt has not been filed. This is the ground, my lord, on which, my lord,
आगे पढ़िए.
money order receipt is the best evidence of the remittance of rent. Out of money order receipts filed exhibit G/2, G/3, G/5 to G/14, G16, G18 to G/27 and many more goes to show that rent was not remitted by the defendant to the landlord through money order within the stipulated period, that is 7th of respective month. From the money order filed by the defendant, it transpires that there is no money order coupon for the month of December 1973, December 1974, February 1975, November 1981, June 1981, August 1981, September 1982, April 1987, February 1988, and May 1988. Therefore, defendants had failed to establish that rent was remitted by him to the landlord for each and every month of the disputed period. Since the defendant has not remitted monthly rent for the period of several months, more than 3 months, therefore they have defaulted in payment.
So where is the error in this finding?
Lordship, the defendants went on remitting rent, my lord, at the rate of rupees 50 per month.
Show me which exhibit is relating to remittance of rent of December 1973, December 74, February 1975, November 1981, June 1981. ये कौन सा exhibit है? Exhibit number बताइए.
देखना होगा.
देखना क्या होगा? क्या देखना है? ये finding पर, ये finding of fact पे थोड़ी आपका substantial question अपना वो बन जाएगा.
हम ये बोल
There
नहीं
is a
रहे.
clear finding that you have defaulted
Clear
in
finding,
payment
but
of
my
rent.
lord, my submission is, Lordship may kindly see. This is not a case of default. The defendant, my lord, went on remitting rent to the
कहाँ
plaintiff.
से आप
हम
there is a
exhibit-
finding that these documents
Lordship-
are not relatable to these months. There is a finding to that.
Lordship, exhibit 5, exhibit F to exhibit F/281.
क्या समझे हम इस-
There are altogether, my lord, 281 money order coupons.
और कितना month का default होगा?
Default तो
अगर 72 से count भी कर लेंगे तो कितना महीना होगा? बताइए. कब से default का इन पर allegation है? September 72.
September 17.
72 का 4 महीना. ठीक है?
ठीक है.
उसके बाद सूट का फाइल हुआ 87 में, राइट?
हाँ.
कितना महीना हुआ? हाउ मेनी मंथ्स?
सूट फाइल हुआ 87.
14 साल तो क्लियर हो गया और 87 में कैलकुलेटर दीजिए. कैलकुलेटर दीजिए समीर जी. सूट आपका 87 में कब फाइल?
20th of April 1987.
तो 120 मंथ्स के डिफॉल्ट
ये
के लिए
हुजूर-
जस्ट अ मोमेंट 120 मंथ्स के डिफॉल्ट के लिए 282 मनी ऑर्डर रिसीट कैसे फाइल हो जाएगा? 120 मंथ्स के डिफॉल्ट के लिए टोटल 120 मंथ्स 281 मनी ऑर्डर रिसीट कैसे फाइल हो जाएगा?
लेकिन हुजूर अगर 11 वॉन्ट्स पोस्टल रिसीट और मनी ऑर्डर कूपन दोनों मिलाकर और लॉर्डशिप में काइंडली सी द प्रोविजन कंटेंट इन सेक्शन 11(1)(d) of the BBC Act. If default has been committed, my lord, by the tenant for 2 consecutive months, where is the default for 2 consecutive months? Lordship में काइंडली सी
So therefore there is no default for 2 consecutive.
no default for 2 consecutive months.
It also records a finding that it was not remitted by 7th of month. By 7th of each month.
By 7.
ये भी फाइंडिंग है कि 7 तारीख तक आपने नहीं दिया है,
And-
उसके बियॉन्ड आपने दिया।
But my lord, there is no document to show that rent was agreed to be paid on or before 7th of each subsequent month. After expiry of the period of lease,
As per the provision of BBC Act, what is the mode and manner of payment of after the expiry of the as per the provisions of BBC Act, by what time the rent is to be remitted?
Lordship,
As per the provision of BBC Act, is there any time prescribed for remittance of rent for each month?
now Lordship may kindly see the provision contained in section 11(1)(d) of the BBC Act, where the amount of 2 months rent lawfully payable by the tenant and due from his in arrears by not having been paid within the time fixed by contract or in the absence of such contract by the last day of the month. Next following.
So your first submission is that no agreement that rent was to be remitted by 7th of month, correct?
Lots.
Number second, no finding of default of 2 consecutive months.
Lots.
While discussing the money orders.
Lots.
Number 3 point is that finding that the payment was not made as per fair rate fixed by order dated 24/6. Your third submission is that the finding that the payment was not made as per the fair rent fixed by the order dated 24/6/1985 is perverse. This finding recorded by the first appellate court is perverse as the landlord never filed any appeal against the finding of the learned trial court that in spite of fixation of fair rent at rupees 412.5 per month, it will be deemed that the monthly rent was only rupees. यही है. इसके अलावा आपको कुछ बोलना है? और इसके अलावा आपका कोई बहस है? बाद में नहीं रिकॉर्ड करेंगे.
नहीं.
ऑर्डर लिखाने के बाद नहीं रिकॉर्ड करेंगे. You just be very sure about whatever you are saying. पर्सनल नेसेसिटी का कॉन्करेंट फाइंडिंग. अगर आपका ऐसा मान भी लेंगे तो आपको कहाँ से रिलीफ मिलेगा? ये हम लोग बताएंगे आपको.
नहीं.
पर्सनल नेसेसिटी का फाइंडिंग पे तो आप कुछ बहस ही नहीं कर रहे.
ये तो डिफॉल्ट पे होगा. ये डिफॉल्ट है.
और
पर्सनल नेसेसिटी में स्पेसिफिक हमारा डिफेंस है. लॉट्स ऑफ
फाइंडिंग कहाँ है? पर्सनल नेसेसिटी का फाइंडिंग
फाइंडिंग तो उसके फेवर में होगी, लेकिन थोड़ा
ये
एक
दिखाइए ना.
एक
बिना
लाइन
ऐसे
खाली देख लिया जाएगा.
पहले फाइंडिंग दिखाइए उसके
इशू
बाद.
इशू इशू जो डील किया सो दिखा रहे हैं. ये एक बार देख लिया ट्रायल कोर्ट का पेज 38.
इशू कौन सा है? इशू नंबर
इशू नंबर 7.
issue number 7. Okay. Where is the finding of trial court with regard to issue number 7?
7 lordship page 27.
27. पढ़िए. Yes.
7th line from the bottom.
ऊपर से पढ़िए सर, आधा आधा नहीं
अच्छा,
पढ़िए.
नहीं. The plaintiff have stated in para 23 of the plaint about the personal requirement. It has been said by the plaintiff that the family consists of the original plaintiff, her husband, 5 major sons, 3 daughters, 2 daughter-in-law, and 5 children. From the record and from the argument of both the sides, it transpires that the original plaintiff and her husband have died. Her 2 sons are the plaintiff number 1 and 2, and other sons are defendant number 9, 10, 11, and 12. The doubters are the defendant number 13, 14, and 15. It has been stated by the plaintiff that the family is well reputed, renowned, well-known business family. The plaintiff's sons are sitting idle for a long time without any occupation. One of the sons is in service in Dhanbad. All the sons are born and bred in the environment of business. The son in service is not happy. The second son has been engaged in business, dealing in general store in a very small group. The plaintiff's elder son has experience of restaurant business. It was therefore decided that the restaurant business would be set up on the ground floor, and later on lodging accommodation could be arranged in the upper floor for casual visitors of Ranchi. Thus, the plaintiff requires the entire property for entire family, and the property is the most suitable for the business purpose. Now, Lordship may kindly see. The defendants have denied the claim of the plaintiff that they require the suit property. It has also been stated by the defendants that the plaintiffs are in possession of abundant property. It has further been stated that the shop Tip-Top was vacated on the ground of requirement, but the plaintiff did not occupy the same or started any business therein. Though the shop is located at Ranchi Chaibasa Main Road, all the sons of the original plaintiff are engaged in their respective business, trade and service, so none of the sons of the original plaintiff are sitting idle. It is further stated that the plaintiff has about 124 kathas of land with constructed shops in part thereof. So the claim of eviction of the suit premises is nothing but a mere wish and desire of the plaintiff, which does not come within the purview of section 11(1)(c) of the BBC Act 1982. It is further stated that the demolition of the present suit premises and then to construct new building and thereafter to start a business of restaurant is the desire of the plaintiff, and so this construction itself cannot be said to be a legal plea under section 11(1)(c) of the BBC. Now, Lordship, may I see the findings? Findings, Lordship, may kindly see page 49.
Page
49.
running page 49.
Running.
Internal.
Internal page 38. In view of the aforesaid discussion, I found that the suit property is situated over the main road and there are big hotels, marketing complex, etc. near the suit premises, and it is best suited for the restaurant business, and as defendants have failed to prove that the shops or other premises are available to the plaintiff to start restaurant business, therefore in view of the aforesaid facts and circumstances of the case, I found and hold that the suit property is reasonably and bona fidely required by the plaintiff for their personal use and occupation.
What about the first appellate? appeal number 7,
Lordship,
return on page 40,
41,
41. Learned lower
learned
court.
law.
Yes, continue.
Learned lower court on the basis of oral and documentary evidence on behalf of the parties has reached to the conclusion that the two premises is fit for restaurant business and the plaintiff have no other vacant shop or premises on the main road for said business. After perusal of the oral evidence on behalf of the plaintiff and defendants as stated above, plaintiff and their witnesses have clearly stated that except the two persons in the large family of the plaintiff, all are idle. Admittedly, plaintiffs have two shops on the main road and two members of the family are engaged in medicine and tailor business. Though the defendants have stated that all the members of the plaintiff are engaged in their business, but they failed to show that except aforesaid members of the family, all the plaintiffs are engaged in business. After discussing various case laws and the evidence of both the parties, learned lower court has reached to the conclusion that property is best for restaurant business and defendants have failed to prove that the shops and other premises are available to the plaintiff to start restaurant business and therefore learned lower court held that the shoe property is reasonably and bona fidely required by the plaintiff for their unused as well as for the use and occupation of the family members in good faith. After going through the evidence adduced by both the parties, I also find that though it has been stated by the defendant that plaintiff Vijay Saraugi has no experience of restaurant business, but Exhibit 13 deed of dissolution of partnership and Exhibit 2 income tax assessment order clearly shows that plaintiff number 1 was doing restaurant business in the name of Sarkar Hotel. Further, I find that proposed business of the restaurant cannot be successfully run by partial eviction from the tenant of the suit premises. Therefore, after considering the entire facts and circumstances of the case, I also find that suit premises is bona fidely required by the plaintiff for their own use and occupation of the family members in good faith. Accordingly, this issue is decided in favor.
What do you have to say on personal necessity?
Necessity, Lordship. There is a specific pleading, my Lord. Lordship may kindly see. Lordship may kindly see. There is a specific pleading, Lordship, in which it has been
Who's
asserted.
pleading? Plaintiff or defendant?
Defendant. Defendant.
Which para number? Tell us in which paragraph that
It has been recorded in the trial court judgment, Lordship may kindly see page 27, Lordship.
internal page?
Internal page.
Yes.
The defendants have denied the claim of the plaintiff that they require the suit property. It has also been stated by the defendant that the plaintiffs are in possession of abundant property. It has further stated that the shop tip-top was vacated on the ground of requirement, but the plaintiff did not occupy the same or started any business there. There is no finding, Lord. Though the soap is located at Ranchi Chaibasa main road, all the sons of the original plaintiff are engaged in their respective business, trade and service. It is further stated that the plaintiff has about 124 kathas of land with constructed soaps in part thereof. So claim of eviction of the two premises is nothing but a mere wish.
Or the Learned Council appealing on behalf of the applicants. Why you?
I am the defendant.
You have no role to play अभी substantial
Justice
question
Milord,
होगा।
Lordship, I put a query Milord with respect to the corresponding cases number. That will nothing else.
आपका केस नंबर कौन सा था? पुराना वाला से तो कोई बहस भी नहीं
नहीं,
हुआ।
नहीं, पुराना
They are not
वाला-
referring
नहीं,
to
नहीं।
that.
Therefore, Lordship, since Lordship has put a query Milord, I am just answering.
बिना बात किए आपसे क्या काम है? You are not supposed to be heard. अब क्या चीज़ बताना चाहते हैं? कुछ इन्होंने गलत समझी।
नहीं नहीं Milord, just a query था Milord, उसको खाली बस सबमिट कर दो। अगर परमिट करें।
हाँ बताइए। क्या?
Milord, the one of the argument was the rent was not tendered on the date. Since date was not fixed, Milord. Milord, kindly take Milord. One thing Milord at page number 37 of the appellate court judgment, Milord. Page number 37.
Yes.
In the opening line, in the case of title suit number so and so, exhibit 9 is the agreement of lease between original landlord and the original partners of Netsen Sports, which the predecessor of the present defendants, from which clearly transpires that the monthly rent which was due for a month was to be paid on or before 7th of that month. Lord, same is the case with respect to next page, page number 38, Lord,
It is
last.
a non-registered document. No?
Yes.
How do we see the terms and conditions of the agreement? By
For the
reference.
collateral purposes can be seen.
What collateral purposes? If there is a terms and condition that the rent has to be fixed, paid at a particular date, that is not a
That
collateral
does not
purpose.
require registration because it
It
is.
is not a collateral purpose. He has not even argued on that.
No,
You
no,
are
no, no.
unnecessarily drawing attention of this court, of which he has not even argued. That is not his case. And this is absolutely, you just can't read the terms and conditions of it.
Lord, just to show me, Lord, the date was fixed for payment, Lord. That's all, nothing else. 7th of every month and subsequently 10th of every month. As I exhibited, these are documents which are exhibited here also. And subsequently, page number 38, Lord, it is 7th of every month. But initially, Lord, the suit was filed in 1983.
This is with respect to title suit number 8 of 1987.
In the page number 38, Lord, it is 9 of 87 also. Page number 38, 9 of 87.
And after expiry of the period of lease lordship, the defendant became a month-to-month tenant.
And Lord, with respect to the initially the title suit was filed in 1983. Because of the change of pecuniary jurisdiction, Lord, the plaint was returned and thereafter, Lord, 1987 suit was filed. Initially 1983, Lord. As on date, Lord, still I am in a tenanted premises and paying a rent of rupees 86,000, as on date. And this is not required, Lord, also, just assisting.
एक तो आपको कोई jurisdiction नहीं है बहस
Lord,
का।
I-
उसके बाद एक बार आपसे पूछिए तो कुछ भी बहस करते जाते हैं। Why do you need to argue all this?
Okay.
जो इन्होंने बहस भी नहीं किया, कुछ नहीं किया, वो आप unnecessary बहस करके क्या ड्रॉ करना चाहते हैं? आपको लग रहा है आपको बिना सुने सेकंड अपील डिसाइड कर देंगे? एट बेस्ट क्या करेंगे? सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम करेंगे। आप तैयारी नहीं होंगे अगला डेट में बहस करने के लिए, फिर आप बोलेंगे कि हमको टाइम चाहिए, राइट? रिकॉर्ड आने में कितना टाइम लगता है? मैं स्पेशल मैसेंजर कॉस्ट 2 दिन, 4 दिन, 1 हफ्ता। But I am not satisfied with substantial question of law. Unnecessarily you are pulling the legs. I am not at all satisfied with substantial question of law, whatever he has argued. For the learned counsel appearing on behalf of the applicant. This appeal has been filed against the judgment dated 6/10/2016, within bracket decree signed on 25/11/2016, that it was passed by the learned additional judicial commissioner Mumbai branching, whereby title appeal number 146 of 2009 has been dismissed, and the judgment dated 31/10/2009, within bracket decree signed on 13/11/2009, bracket close, has been confirmed. The judgment was passed by the learned. The trial court judgment was passed by the learned sub-judge Roman to granting in eviction within bracket title bracket close suit number 9 of 1987. And the eviction suit was decreed. The learned counsel for the appellant, while advancing his arguments, has submitted that the present appeal is the defendant's second appeal. And although the defendant has lost in both the courts, but still there are substantial questions of law involved in this case. And therefore, substantial question of law be framed and decided. The learned counsel has submitted that 3 title appeals arising out of 3 different eviction suits were decided by common judgment, and the present appeal arises out of eviction title suit number 9 of 1987, corresponding to title appeal number 146 of 2006. The learned counsel submits that the eviction title suit number 9 of 1987 was filed seeking eviction of the defendant on ground of default in payment of rent. Right from September 1972, and also for personal necessity. The learned counsel submits that the relationship of landlord and tenant between the parties is not in dispute. And defendants defendant had categorically denied the allegation of default in payment of rent, inasmuch as the rent was being remitted at the rate of ₹50 per month through money order, and this was substantiated by exhibiting the money order receipts. And money order coupons which were exhibited as Exhibit D to D by 164 and Exhibit F by F to Exhibit F/281 respectively. The learned counsel submits that as per the provision of section 11 within bracket 1 within bracket D of Bihar Building within bracket Lease, Rent and Eviction bracket Close Control Act, in order to maintain a suit for eviction on ground of default in payment of rent, कंजिक्यूटिव तो नहीं लिखा है इसमें, कंजिक्यूटिव तो नहीं लिखा है मिस्टर, कंजिक्यूटिव तो नहीं लिखा, कंजिक्यूटिव 2 months तो नहीं लिखा,
Consecutive पे judgment होगी।
नहीं नहीं कहाँ है कंजिक्यूटिव?
Where the amount of 2 months rent lawfully payable by the tenant and due from him is in arrears by not having been paid within the time fixed by contract,
इसमें तो कहीं
or
कंजिक्यूटिव
in
नहीं
the
लिखा,
absence of such contract,
इसमें तो कहीं कंजिक्यूटिव नहीं लिखा,
consecutive months है।
कहाँ लिखा है?
दे रहे हैं judgment दे रहे हैं।
लीजिए, नहीं तो हम यही बोलेंगे कि आपने कुछ नहीं। The default in payment of rent should be for 2 consecutive months, but the findings of the learned trial court does not reveal that there was default in payment of rent by 2 consecutive months. The learned counsel has further submitted that as per the aforesaid provision under section 11(1)(b), the rent has to be paid by the last day of the month next following that for which the rent is payable, and therefore the finding of the learned court that the rent was not paid within the agreed period of 7 days, agreed period by 7th of every month, is also perverse and not in accordance with law. The learned counsel has further submitted that the agreement on the basis of which such a stipulation has been read was an unregistered document and was not admissible in evidence. And therefore, the terms and conditions of tenancy that the rent was to be paid by 7th of each month was not applicable. The learned counsel submits that finding of the learned courts that the appellant was in default in payment of rent in terms of section 11(1)(d) of the Aforesaid Act of 1982 is not in accordance with law. And therefore, a substantial question of law will change as to whether the appellant could be termed as a defaulter in payment of rent. In the facts of this case. The learned counsel has also submitted that the learned trial court had recorded a finding that in spite of fixation of fair rent at the rate of rupees 412 per month, 0.5 per month, by it order dated 24/6/1985 it would be deemed that in the present case, the last paid rent, that is rupees 50 per month, shall be deemed to be the fair rent and not fair rent as fixed by the controller in fair rent proceedings. But the learned first appellate court has recorded a finding that the payment was not made as per the fair rent fixed by order dated 24/6/1985, and consequently the defendant was a defaulter in payment of rent. The learned counsel submits that such a finding could not have been recorded, as the finding of the learned trial court that rupees 50 would be the deemed rent for the premises irrespective of the order dated 24/6/1985 passed by Parent Controller, and no cross appeal or cross objection having been filed with regard to such a finding, there was no scope for the First Appellate Court to differ with that finding and record a finding of default in payment of rent by referring to the order of fair rent fixed by the order dated 24/6/1985. Yeah. हाँ, कौन सा जजमेंट आप बोल रहे थे कंसेक्यूटिव का बता दीजिए, बताइए.
Consecutive months, Lordship may kindly see the provision itself, Lordship, where the amount of 2 months rent lawfully payable by the tenant and due from him is in arrears by not having been paid within the time fixed by contract. Itself says not 2 consecutive months.
ये जजमेंट नहीं है 2003 का वॉल्यूम 4 2003 का वॉल्यूम 4 462 वॉल्यूम 4 PNGR 462. ये तो इसका हुआ, ठीक है. आई विल गिव फर्दर डिक्टेशन टुमारो, क्योंकि जजमेंट तो आप लाइन नहीं,
हम
तो
अभी
हम तो रेफर बिना की जजमेंट नहीं लिखा सकते. कल हम सुनेंगे नहीं, आप
नहीं,
लेके
हम
नहीं
अभी
आए.
दे देंगे
लीजिए,
जजमेंट, आप
बताइए.
दिखा दीजिएगा. नहीं,
लिखा
अभी हम
नहीं.
दे देते हैं तुरंत अभी.
तो आप जजमेंट ही नहीं लेके आए हैं, आप बहस कर रहे हैं कि 2 कंसेक्यूटिव होना चाहिए,
Lordship may kindly see the
बिकॉज
provision.
एक्ट में तो नहीं लिखा है कंसेक्यूटिव होना चाहिए. कंसेक्यूटिव वर्ड इज नॉट यूज्ड इन दैट. Nor I will buy this argument of yours in absence of any judicial pronouncement that it has to be consecutive to 4. Unless you show some judicial pronouncement, I will not buy that argument. बताइए। आपको तो पता ही होगा। I will not give you the benefit of ignorance.
पता है हुजूर,
वो
लेकिन
तो हम आपको नहीं दे सकते।
5 मिनट का खाली समय दिया तो
वो
जब 2 consecutive months हुजूर settle principle of law.
आपका सेटल्ड है तो भाई हम तो नहीं देख रहे हैं
2
सेटल्ड।
consecutive months ही होगा, जनवरी और मई तो नहीं हो सकता है।
क्यों नहीं हो सकता?
हुजूर को
As
पता
per
है-
the provision
नहीं,
of law क्यों नहीं हो
हुजूर को पता है वैसा नहीं होगा, 2 consecutive months ही है।
हमको नहीं पता है,
देंगे हम, दे रहे
इसीलिए
हैं।
आपसे पूछ रहे हैं।
जजमेंट लाए नहीं हम दे रहे हैं, 2 consecutive months है, गलत सबमिशन नहीं करेंगे।
ऐसे नहीं लेंगे आपका ये सबमिशन। Because judgment error not being 2000 volume 2 India 509. 2000 का volume 2 PNJ 509. Economic 95 का volume 2 create किया 1995 volume 2 create किया। ठीक है, आपका आर्गुमेंट इसमें कंटिन्यू है। आगे बताइए दूसरा केस कौन सा है? सेम दैट इज इन रिलेशन टू ऐसे नंबर कौन सा है? ऐसे नंबर 38 है ना, ऑफ 2017। एक तो आपका विड्रॉ हो गया है ऐसे 37 ऑफ 2017 दैट यू आर विड्रॉन।
During the pendency of the second appeal, Lordship, tenant has handed over the vacant possession of the premises to
In the present case,
therefore, no, second appeal was permitted.
लिखिएगा इसका लिखिए, essay number 38 of 2017. Third, the learned counsel for the appellant. This appeal has been filed against the judgment dated 6/10/2016 with the bracket decree signed on 25/11/2016, bracket close, passed by the Additional Judicial Commissioner, Roman 5 branching, dismissing title appeal number 145 of 2009 and confirming the judgment dated 31/10/2009 with the bracket decree signed on 13/11/2009. Passed by learned subject Roman 2 branching in eviction with the bracket title, bracket suit number 8 of 1987. इसमें मनी ऑर्डर रिसीट्स जो है, पोस्टल रिसीट्स आर एग्जिबिट B2 B by 156 and money order coupons are exhibit A2 A by 198. लगता है छूट गया, ये भी दोनों में जाएगा, ठीक है, बोनाफाइड रिक्वायरमेंट वाला छूट गया. With respect to the findings of both the courts regarding bona fide requirement of landlord, the learned counsel for the appellant has submitted that it was a specific case of the defendants who had denied the claim of the plaintiffs with regard to requirement of the suit property. And it was stated by the defendants that the plaintiffs were in possession of abundant property. He has further submitted that it was stated that the shop tip top was vacated on the ground of requirement by the plaintiff, but the plaintiff did not occupy the same or started any business therein, though the shop was located at Ranchi Chaibasa main road. It was also the case of the defendant that all the sons of the original plaintiff were engaged in their respective business, trade and service, and none of the sons of the original plaintiff were visiting ideally. It was also asserted that the plaintiff had 124 katthas of land with constructed shop in part thereof, and therefore the claim of eviction of the suit premises on account of personal necessity was nothing but a mere wish and desire of the plaintiff, which does not come within the purview of section 11 within bracket 1 within bracket C of the Bihar building within bracket lease, rent and eviction bracket close control act 1980. The learned counsel submitted that the case of the defendant was not properly appreciated by the learned courts, and therefore the finding of the learned courts with regard to bona fide requirement of the plaintiffs is also perverse, for which substantial question of law is required to be framed and answered. Bhakti will please answer. एक तो जजमेंट मिला है दैट कंसेक्यूटिव होना जरूरी नहीं, नहीं 2003 वॉल्यूम 4 की है। नाइनटीन 89 PLR लिखे, 89 PLR 587, PLR 587, 89 में body में नहीं था।
89 PLJR page 587 और 75 पटना 154
एक ही है क्या दोनों?
जी 82 PLJR page 339 ये अगेंस्ट में हुई नॉन पेमेंट ऑफ रेंट शुड नॉट बी फॉर 2 consecutive
Against किसके?
हमारे अगेंस्ट ये
1982.
1982 PLJR page 339
339.
1989 PLJR page 587
587.
AIR 1975 Patna page 1
1985 Patna.
I'm sorry AIR 1975 Patna page 15
75 Patna. Page
154
15. Consecutive होना जरूरी नहीं। आपकी तरफ से नहीं लिखा ना?
नहीं असिस्ट करना जो जजमेंट है
ये सारे जजमेंट्स हम देख लेंगे and I will incorporate it in there. Upon a query made by this court, as to whether there is any judgment which holds that there has to be default in payment of rent of 2 months consecutively. Particularly in view of the fact that consecutive period of default of 2 months has not been mentioned in section 11 within bracket 1 within bracket D of the DVC Act. The learned counsel for the appellant has not been able to show any judgment in his favor. Rather, he has fairly submitted that there are judgments which shows that the default need not be for consecutive months. He has referred to the judgment passed by Honorable by this court / Patna High Court by Honorable Patna High Court reported in 1918 AIR 1975 Patna 154 semicolon 1982 PLJR 339 and 1989 PLJR 587. Consequently, this court has perused the various judgments, including the judgment reported in 1989 PLJR 587, wherein it has been clearly held that this court in paragraph 13, that this court on a number of occasions, that for the purpose of coming into finding that the tenant had become a defaulter in respect of 2 months' rent lawfully payable by him, it is not necessary that the tenant would default in payment of rent of 2 consecutive months. And reference has been made to the earlier judgments. Paragraph 13 of the opposite judgment is quoted as under. The state judgment has also been followed by Patna High Court, in judgment reported in 2003, 4 PLJR 462. And therefore, it is not in doubt that the law is well settled that in order to attract section 11(1)(d) of the aforesaid Act of 1982, the default need not be for consecutive months. पेज मैच नहीं कर पेज नंबर कितना 509 In another judgment reported in 2002, PLJR 509, in second appeal number 48 of 1992, R, similar view was taken. उसका वैसे जरूरत नहीं पड़ेगा, लॉ सेटल पुराना से ही सेटल है।
75 से डिवीजन देते हैं।
75 वो सब हम डाल देंगे। 75 वाला जो है ना, 75 पटना 154 है ना, इसको लेते हैं, इसका प्रिंट देंगे। 75 पटना AIR 75 पटना 154। आज कितना तारीख है? देखिए जरा, after hearing the learned counsel for the appellant and going through the materials on record, this court finds that the following issues were framed by the learned trial court. And essentially the arguments have been advanced with respect to issue number Roman 5, Roman 6 and Roman 7. The relationship of landlord and tenant is not in dispute. The trial court, by deciding issue number 5, has taken note of the fact that the house rent controller, while order dated 24/6/1985 had fixed the fair rent at rupees 413.50 per month. Was of the view that the last paid rent was rupees 50 for each month, which would be deemed to be the fair rent and not the fair rent fixed by the controller, because the fair rent proceeding was pending and was finally disposed of during the pendency of the suit. This finding was recorded in spite of the fact that fair rent was already fixed by the order dated 24/6/1985, and the suit was instituted in the year 1987. The learned trial court. Further appreciated the documents filed by the parties, filed by the defendant with regard to payment of rent, and the discussion in connection with default in payment of rent. Has been recorded. At internal page 16 of the trial court judgment. And further discussion is at internal page 23 of the trial court judgment. Which is quoted as under. This court finds that after elaborate discussion of materials on record, the learned court recorded that the defendant was a defaulter in payment of rent. The learned first appellate court has also recorded concurrent findings after appreciating the materials on record. 10 है कि 9 है? 9 से ये ना इविक्शन सूट नंबर 9 से गलती से 10 वाला मार्क किए हैं, 9 से लेंगे 9 से लेंगे विद रेस्पेक्ट टू सेकेंड अपील नंबर 36 ऑफ 70. This court finds that the learned first appellate court has also recorded concurrent findings with regard to default in payment of rent at running page 38 of the appellate court's judgment, which is quoted as under. The learned first appellate court also recorded a finding that the defendant did not remit the fair rent which was payable in terms of the order passed by the rent controller dated 24/6/1985. The fact that the rent controller had fixed the rent at rupees 412.50 per month was also not in dispute. This court is of the considered view that merely because the landlord had not filed any cross appeal or cross objection with regard to the finding of the learned trial court that the fair rent would be deemed to be at the rate of ₹50 per month, irrespective of the fixation of fair rent by the competent authority, that is the house rent rent controller, by order dated 24/6/1985, has no bearing in the matter inasmuch as the point regarding default in payment of rent was directly and substantially in issue, and before the learned first appellate court, and the learned first appellate court being the final court of fact and law was required to consider every aspect of the matter while dealing with the point of default in payment of rent. Accordingly, the arguments of the learned counsel for the appellant with regard to formation of any substantial question of law on the point of default in payment of rent is not acceptable to this court. This court is of the view that so far as the finding with regard to default in payment of rent is concerned, no substantial question of law, much less no question of law, much less any substantial question of law is involved. So far as the point regarding personal necessity is concerned, this court finds that the learned trial court as well as the learned first appellate court has duly considered the case of the respective parties and has considered the same at internal page 34 of the judgment, which is quoted as under. The further arguments of the defendant has also been recorded in continuity in paragraph in internal page 35 of the trial court judgment. The learned trial court also recorded that the plea of availability of alternative building to enable the plaintiff to start the business was also not proved inasmuch as there was no proof that the alternative building was suitable, and therefore, in absence of such proof, it could not be concluded that the personal necessity was not bona fide. The learned trial court also considered the fact as to whether partial eviction could be considered, but that such consideration was also rejected. The learned court also recorded that there was no evidence as to whether tip-top premises were suitable for the business of the restaurant or not. The learned trial court, after elaborate consideration of materials on record, has finally come to the conclusion in page number 38 as under, so highlighted as report. So far as the learned first appellate court is concerned, the case was, the matter was considered affluent and the plea against bona fide necessity by the landlord was decided in favor of the plaintiffs. And learned first appellate court also recorded while deciding issue number 7 that the suit premises was bona fidely required by the plaintiff for their own use and occupation of the members in good faith. And the judgment of the learned first appellate trial court on this point was upheld. This court finds that there are concurrent findings recorded by both the courts on the point of default and on the point of personal necessity. And both the courts, after scrutinizing the materials on record, gave findings in favor of the plaintiffs. There is no scope for reappreciation of materials on record at the stage of second appeal in absence of any perversity. No perversity in the matter of evidence as such has been pointed out by the learned counsel by the appellant during the course of hearing, calling for any interference in the evidence. They calling for bringing in substantial question of law. In view of their course of facts and circumstances, this court finds no merit in this appeal, which is discussed. There will be corrections. I will. These are online proceedings, that is why I am making it clear. There will be corrections, but my prima facie and complete view is that there cannot be any reappreciation of material. और आपका वो वाला जो point था कि no cross appeal was filed, that I have dealt with specifically, and your point that there has to be consecutive, that also I have dealt specifically. Bona fide necessity का findings is already recorded with that.
Just to assist my lord, there are two judgments which can not take care of lord. It's in the default is a question of fact, my lord, which cannot be appreciated.
Sorry?
Lordships of places.
Sorry?
Your default is a question of fact. There's a disregarding lordships of places can incorporate this.
Then
But there's a one more. When my execution case is pending, lord, it can be expedited if possible.
what experience?
Lord, in terms of Rahul S. Shah judgment, lord, 6 months time frame has been given, lord.
क्या यहाँ पे हम क्या करेंगे? यहाँ से स्टे था क्या?
Stay anything.
तो फिर आप क्या कर रहे थे एग्जीक्यूशन? यहाँ से स्टे नहीं था ना?
Stay.
तो फिर स्टे नहीं होने पर भी आप एग्जीक्यूट नहीं करा पाते हैं. आपको कोर्ट का ऑर्डर चाहिए. कोर्ट का ऑर्डर से एग्जीक्यूट करा लेंगे. बताइए.
हो नहीं पा रहा क्योंकि कुछ ना कुछ
आप बताइए कितना दिन में ये खाली कर देंगे? आप बताइए यू हैव एनी इंस्ट्रक्शंस ऑन दैट? कोई ऐसा इंस्ट्रक्शन नहीं है. क्योंकि अगर कोई ऐसा रहता है तो हम लोग टाइम दे देते हैं 6 महीना या व्हाटएवर. दैट टू विद योर कंसेंट, अदरवाइज तो नहीं दे सकते.
It's for almost 80 years therefore my life playing the TNC.
80 साल से आपको रेंट दे रहे हैं अभी भी कि नहीं दे रहे हैं? अब बंद हो गया रेंट भी बंद हो गया.
1945
हाँ, दोनों डिस्मिस. 50 रुपए भी देना बंद कर दिए क्या? हाँ?
कुछ नहीं मिल रहा.
50 रुपए भी देना बंद कर दिए. This is too much.
Item 6, second to 238 of 2023.
Mr. Rohitashi has to argue in this case.
Sorry?
Mr. Rohitashi has to argue in this case.
So what should I do?
He is in on let's in court number 3. We were asked to produce certain judgments. We have brought the judgments.
Where are they? Which paragraph?
Judgment citation of 2008, paragraph number 8.
Read it, please.
It is well settled principle of law that in a suit of eviction, if the defendant tenant fails to comply with the direction for deposit of rent in compliance of order passed under section 15 of the Bihar Building Lease Rent Control Commission Code, the defense of the defendant co-tenant is struck off, meaning thereby the defendant tenant cannot defend the suit for eviction as a tenant, but he can defend the action on the ground that he is not a tenant and can establish title in himself. In other words, in a suit for eviction, if the tenant disputes the relationship of landlord and tenant and claims title himself, he can adduce evidence to that effect.
That was not our question. Our question was what is the consequence of striking of defense?
Yes, Your Lordship.
Whether the evidences which have been put on record
Yes, Your Lordship.
also they struck off.
No, Lord.
Which judgment are you relying on?
We are not this we were not able to find the relevant judgment. It may be found out for just one or two cases.
For hearing item 7, second to 72 of 2018.
Lord's judgment of reversal. Trial court executed the suit and in appeal, the appellant has lost the case. The suit was filed for eviction on the three grounds also. Number one, default in payment of rent.
Default in payment of rent. Default.
Number two, material alteration in the building by constructing the showroom.
Yes.
Number three, personal necessity.
It was allowed on all the 3 points.
Two grounds.
Which ground?
Number one, default in payment of rent and personal necessity. But regarding alteration,
Eviction on ground of default and personal necessity. Okay. Appellate court.
in appeal, Lord said, both the two grounds have been negated by the appellate court. No cross appeal was preferred by the appellant regarding the material alteration also.
Alterations. आप किससे
Respondent.
बैठ जाइए. Yes.
The ground for the trial court decreed the suits on regarding default in payment, there was an unregistered agreement. I am not relying on it also.
Agreement dated.
Agreement dated 1499.
Exhibit.
Exhibit 1.
So default was primarily decided on the basis of unregistered.
Lordship. It was the case of the plaintiff.
It was a clause which was taken into consideration.
It was taken not into consideration, Lordship.
Is there,
I am not denying, Lordship. On the exhibition, I am not denying. I am totally concentrating my argument on your personal necessity, Lordship. Just to cut short the matter.
so default has been upheld?
Default, no. Trial court dismissed that ground.
No, you said that the eviction was
Yes,
on ground of
yes.
default and personal necessity.
Just in by the trial
That
court.
was decreed by the trial court.
Correct.
The first appellate court upheld this finding.
No. Appellate court
Reverse both the findings.
Lordship.
Okay.
Reverse the findings, Lordship.
Okay. And now you are only concerned with personal necessity.
Personal necessity, Lordship. State will, Lordship.
You are the landlord?
I am the landlord, Lordship.
एक second. Essay number 72 of 2018. Learned counsel for the appellant. Learned counsel for the parties are present. This second appeal has been filed by the appellant/plaintiff, by the plaintiff against the judgment of reversal. The appellant is the landlord in connection with the suit premises. The trial court, the learned counsel for the appellant has submitted that the suit was filed seeking eviction on 3 grounds: default in payment of rent, material alteration, and personal necessity. However, the trial court decreed the suit on ground of default and personal necessity. And so far as the point of material alteration is concerned, the same was decided against the plaintiff. The learned first appellate court reversed the finding in connection with default and personal necessity, and since no cross appeal was filed by the by the plaintiff in connection with the finding of material alteration by the learned trial court, the suit stood dismissed by the learned first appellate. The learned counsel has confined his argument in connection with personal necessity. However, this appeal was heard to be decided by framing the following substantial question of law by the order dated 9/4/10/2023.
Now only 2 substantial questions law are available to me, Lordship, 1 and 4.
The learned counsel submits that in view of the fact that the appellant does not want to argue in connection with the has confined his argument in connection with the point of personal necessity. Therefore, only 2 substantial questions of law are required to be answered.
Lordship.
One is which are the substantial question of law number 1, which is the finding regarding personal necessity, and the substantial question of law number 2.
Lordship. Now the plaintiff's case was that there are several rooms let out to the different tenants. I am admitting the case of the defendant. And one of the co-owner, my lord may have to, I want to disclose one fact, that this whole property belonged to one Anil Kar. And after his death, his widow, Kamla Bala Kar, and other sons became the owner. So the suit was filed by one of the co-owner, that is Mahadev Kar.
Yes.
Mahadevkar had pleaded in his petition complaint that he requires the suit property for the stationary business of his son Amitkar. He was at present sitting idle. The defendant's case is that there are several rooms have been let out to the different tenants.
Let out. Okay.
And Amitkar is running a Pragya Kendra in his residential house.
Yes.
And his wife also running a school, play school, with the help of the Amitkar.
Whose wife?
Amitkar. For necessity, the premises required.
Was also running a play school in the house.
His wife,
His wife was running
with the help of this Amitkar.
in the house. With help of Amitkar.
That's and one more plea was taken that in February 2014, a showroom was evicted by one of the tenants, and that was given on rent to another tenant. And one showroom also was evicted earlier, which has also been given on rent.
Yes.
So I state will come to the trial court judgment.
Where is the finding?
Proceed. The page 20, running page 20 also
Running page 20.
of the trial court judgment also.
Yes. Issue number 4.
Issue number 4 also. Where that the plaintiff required the suit property for the bona fide and personal necessity.
Yes.
Regarding aforesaid issue, the plaintiff has made averment in para number 8 of the plaint that the suit property is situated by side of the main road and is quite suitable for the purpose of running shop of stationery items for his elder, namely Amitkar, who has got no avocation in his life, and as such plaintiff desires to have the suit property vacated by the defendant for his bona fide personal necessity in good faith for setting his son in business in the suit property. It is further asserted that plaintiff is in a position financially to start a stationery shop for his son, and the suit property is most suitable for the fulfilling the bona fide personal necessity for the plaintiff in good faith as provided under section such and such. In support, the pleading P.W. Mahadevkar has supported and corroborated pleading regarding bona fide and personal necessity of the suit properties by para number 10 of his examination chief. In cross-examination by para number 36 and 37 of his cross-examination, he has admitted facts that other room has been let out to kindness. Other room has been let out to Rajit, to the defendant and tenant Anil Kokrazka, actually Dodrazka, Kokrazka, right. Dr. Goswami, Chiranjeev, Artachaki, and also ladies tailor, and denied the suggestion the suit has been instituted to harass the defendant. PW2 has also supported PW2 Ambedkar for suit premises required. PD regarding bona fide and personality by para number 10 of his deposition and deposed that he wants to start business of the stationery in the suit property and denied the suggestion that he has any greedy eye on the tenanted premises and the suit has been filed. The defendant has not admitted para 9(8) of the PD.
I don't know why this substantial question of law number 4 was framed.
Because the trial court has not taken this view.
Learned appellate court has committed error regarding personal necessity.
The appellate court says
The examination of the owner is cited.
Lordship, he
Owner
says,
has been examined.
Lordship, he says the landlady that Kamala Bharat was not examined, therefore,
Madhav Kar is the co-owner of the property.
Lordship, but
By virtue of inheritance.
Supreme Court decision is there. I just take my note the appellate court's lordship.
एक सेकंड जरा इसको पढ़िए जरा और पढ़िए.
The defendant has not admitted in para number 8 of the pleading of the plaintiff and also further made averment in his written statement that the plaintiff does not require the tenanted premises for the purpose of accommodating of his alleged son. Amit Kar for running shop of the stationery items. Allegedly, he is sitting idle and has not stated the area required by him to run the business of stationery items for his son Amit Kar, and has also not stated that in case the defendant vacates portion of the sold property, his son may start business of the said items and no bona fide personal necessity for the plaintiff at all exists, and the alleged requirement of the plaintiff is not in good faith. The defendant has further made averment in written statement that the plaintiff has number of rooms in his disposal in the said premises on the western side, Chaibasa Jhik Pani Road, and other shops are located in the southern side of main Nimdi Gari Road, and one Sri Naru was accommodated in another room, and the room in occupation was handed over to the defendant for his use, and other rooms situated by the northern side of the Chaibasa Jhik Pani Road have been let out to one Anil Golrajka, Ranjit, Dr. Goswami, Chiranjeev, and recently in the month of February 2014, a shop on the corner of Main Road and Nimdi Gully Road has been let out to husband of Mrs. Suman for running an education helpline under the name and style of PS Helpline. Second and third showroom have been let out to Fort Grinder and Subrata Press respectively, and on the northern western corner of the holding and by the side of Nimdi Gully Road, a showroom was vacated by the previous tenant, which has been let out to a lady tailor who runs a ladies tailoring business under the name and style of Fashion Ladies Tailor. And the plaintiff has no intention to accommodate his son in business for another avocation in life. Otherwise, he would not have let out the vacant shop premises to any other tenants during the pendency or just prior to filing of the suit. It is further asserted the defendant has come to light that the son of plaintiff, Amit Kar, and his wife are running a play school for the toddler minors in his house, and there is no requirement of a suit premises by the plaintiff in bona fide personal necessity and in good faith. In support of the aforesaid pleading in the written statement, the DW1 is Sri Ashok Kumar Mahanti has nothing deposed in course of his examination as witness. Rather, the appellate court has said that this witness has supported the case of the defendant. There is a contradiction. DW2 Dr. Ranjit Prasad has supported and corroborated facts of the pleading involved in this suit as a defense by para number 18 and 19 of his examination chief. He has deposed that it is not proved and correct that Amit Kar, eldest son of the plaintiff, wants to open a shop of the stationery because he is employed. He has further deposed that he was self-employed and running Pragya Kendra at his house, and his wife engaged in teaching of children of play school. He has further deposed that several rooms in the tenants in the same building of the suit property, and in the month of 2014, plaintiff has let out one room to Yes Helpline, which was got vacated from a lady tailor. And if the plaintiff had in bona fide requirements, then the was not to let out the said room on rent. There is also filed a sketch map of the holding in the court, which has been marked earlier E. In his course of examination by para number 56 of his disposition, deposed that he does not know how much money is being earned by Mr. Mitkar from Pragya Kendra. Having regards pleadings of the parties of the suits and their evidence, oral and documented, consider the arguments advanced on behalf of both the parties, it is made evident that the suit property that is comprising of one shop and hall, that is important, Lordship. One shop and hall is situated by side of the road, appears to be suitable place for the running of the business by the son of the plaintiff. It is further evident the defendant has brought oral evidence on the judicial record regarding let out another room to the other tenant, but that landlord had choice to select most suitable premises for his own use, and it come under purview bona fide and reasonably in need of the suit property. In view of the aforesaid discussion, the issue is conclusively adjudicated and determined in favor of the plaintiff and against the defendant.
What is the finding of the learned?
Lordship, I- Lordship. Issue has been filed, Lordship, of page 14.
The relevant portion would be at page number 15 of the appellate court judgment.
Lordship.
Para 30. Third question.
Not Lordship. May I read, Lordship? Para 13 onwards.
Yes.
It is
First
at-
is it is quoted the provision of JPC Act,
Lordship, Lordship.
and then para 31 you can read. It's a short judgment.
Lordship.
It is admitted case of the plaintiff, that is Mother Mangla Balakar is the actual owner of the property,
Lordship.
but she was not come forward to support the case of the plaintiff. Hence, personal necessity is not sustainably in the
Number one, Lordship. Whether such landlord is required to come in the witness box or not, or once the need of bona fide necessity is established, then there is no question of examining any other witnesses. Supreme Court and Patna High Court both also. Now come to Lordship, another page 21, para 21 also.
21.
My lord may skip it. And mistake to come to the Lordship. 28, page 15, para 28.
Page 15 para.
No, so para 30 also, para 30. The third question.
We have read it.
Third, but that is not para 30 also.
Para 30. First we have quoted this, and para 31 is the findings.
The third is the appellate court wants to say that under the definition of the bona fide requirement, agent does not come. Agent that I totally agree. He has taken the act of the Supreme Court judgment is totally inapplicable in the correct circumstance of this case, Lordship. Just see the explanation attached to this section, Lordship.
That's right.
Explanation 1. In this clause, the word landlord shall not include an agent. Lordship, I agree. I am not agent.
You are not an agent. You are the
One of the
son of the one of the co-owners.
one of the corner.
So according to you, for the fourth substantial question of law, is an error. Where are the other rooms located which have been?
There are some on the front side, they are on the back side of the same premises. And my residential house is not in that premises, it is a distant place. Where he said that I am running a school with my wife and with Pragya Kendra. So now when my lord see, my lord was aware about the spectrum of personal city, what are the principles regarding, there may be 100 rooms. So what would be the sufficient or suitable for that?
It is for the landlord to decide.
Lord,
Otherwise, also there is an explanation.
So there was a
Where
kind
there are 2 or more premises let out by the landlord, it will be for the landlord to choose which one would be preferred by him.
there was a smaller portion and the dependent is possessing a bigger portion. So that is suitable for me, Lord. This is the argument, Lord.
You were seeking eviction of which property? Area?
Area, Lord, given the rank,
11 feet into 10 feet.
Lord.
And 1 hall.
That is how Schedule A. The house and premises standing on portion of plot number such and such, situated in Mola, Chota Nimdi, within ward number itna, Chaivasa itna, Sadar, comprising of one room measuring about 1140, one hall measuring 36 into 24, and one room constructed measuring about 10 cents.
Yes, what do you want to say? Yes, one. Yes, ma'am.
May I take my seat?
टू डे टाइम ड्यू टू
आप इतना देर से क्या कर रहे
हम उसी के लिए खड़े हुए थे मैम
किसके खड़े हो? हम तो आपसे पूछे किसके खड़े हैं?
हमसे गलती से ना वो फाइल दूसरा आ गया इसलिए सिर्फ कल परसों
घर में पढ़ना जरूरी नहीं
नहीं
है।
हम वो मतलब उनसे भी उठा के लिए दूसरा फाइल ये जो कि परसों डिसाइड हो गया था ये सेम ही मैटर का सेम ही लैंड टेनेंट का एक मैटर डिसाइड हुआ है एक तारीख
क्या
फाइल आ गया गलती से वो फाइल आ गया कल हम पढ़ के रखे उसको नहीं सिर्फ कल भर
नहीं ये सब क्या तरीका है? फाइल छूट
ये
गया
मेरी
घर में।
गलती हम उसको देखें नहीं हम उसको बोले रखे मेरा फॉल्ट है
तो क्या करें हम लोग आपको?
इसको कल भर सिर्फ हमको
जब
परसों
आधा घंटा से सुन रहे हैं तो क्या इट्स अ वेस्ट ऑफ टाइम।
जब सिर्फ परसों इसको लेंगे, कल
ऐसे नहीं कर सकते। फाइल मंगाइए घर से तो क्या मतलब है? ऐसे नहीं हो सकता है। आपको जब मन होगा खड़ा होकर बोलेगा आपको इतना देर से बहस कर रहे थे क्यों नहीं बोले? Why didn't you say? आप तो एक शब्द नहीं बोले। I asked you also that why are you standing? Are you the respondent? You said yes or badly. Okay? इस ground पर time नहीं होगा। I will not grant you time on this ground.
ठीक है तो इसको सेकंड हाफ रख लेंगे तो सबका जीरोक्स करा के देख लेते हैं
देखिए आप इनका जेरोक्स करा के दे देते हैं।
And then बात दे देंगे।
इस तरह से कोर्ट प्रोसीडिंग नहीं चलता है ना।
खड़े हो
देखिए
गए थे
तो
लेकिन
थोड़ा सा और लिखिए। The learned counsel for the appellant has submitted that the suit property was belonging to one Anil Kar, and upon his death, it devolved upon his widow and sons. And the suit was filed by the co-owner, namely Mahadev Kar, son of Anil Kar. He submits that the suit premises was required for stationery business of son of Mahadev Kar, namely Amit Kar, who was sitting idle. He has submitted that several rooms were let out to different persons, and Amit Kar was running a Pragya Kendra in his residential house, and his wife was also running a play school in the house with the help of Ambedkar. The suit premises was required to start the stationery business. The Learned Counsel has further submitted that in February 2014, a shop room was evicted. Another shop room was evicted, which was given to another person as tenant, and one shop room was evicted earlier, which was also given on rent. The Learned Counsel has submitted that the law is well settled, that it is the choice of the landlord as to which property would be the most appropriate property for the proposed utilization by the landlord. He has submitted that the Learned Trial Court had recorded finding in favor of the plaintiff so far as personal necessity is concerned, but the Learned First Appellate Court while considering the plea of personal necessity, quoted the provision of section 11(1)(c) of the APC Act in paragraph 30, and by referring to a judgment of Honorable Supreme Court in the case of M.M. Wasim versus Manohar Lal Sharma, reported in 1981 BLJ 535 SC. The Honorable Supreme Court has held that the landlord under section 11(c) means only the owner of the premises having right against the whole world to occupy the building, and does not include one or the other agent or legal representative in the assignment. And by referring to the said judgment, the Learned First Appellate Court was of the view that in order to bring a case of personal necessity under section 11(1)(c), the definition of landlord does not include co-pastor and co-sharer. He submits that the Learned First Appellate Court also recorded that it was a alleged case of the plaintiff that his mother, Srimati Mangla Balakar, is the actual owner of the property, but she had not come forward to support the case of the plaintiff. And on such finding, the Learned First Appellate Court has recorded that personal necessity was not sustainable in the eyes of law. The Learned Counsel says that ultimately the Learned First Appellate Court recorded a finding at paragraph 32 that the case of the plaintiff was quite contrary to the settled principle of law, and answered the question in favor of the tenant who was the appellant before the court and against the respondent landlord. The Learned Counsel submits that while the Learned First Appellate Court had committed error regarding personal necessity, that by observing that regarding personal necessity, the examination of the owner is sine qua non. Service said it was not necessary for Srimati Mangla Malakar to be examined before the court, as the plaintiff was the co-owner of the property and he was seeking the property for the personal necessity and use of his son, namely Anil Kar. The learned counsel submits that the learned first appellate court was not justified in reversing the finding of the learned trial court with regard to the personal necessity of the appellant. बस आपका हो गया आर्ग्यूमेंट खत्म.
My lord.
सेकेंड हाफ में टाइम मिलेगा तो आप तो सुनेंगे, नहीं तो कल सुनेंगे.
कल इसी वो परसों सुबह फर्स्ट के
कल
साथ-
परसों 2-3-4
कल-
साल
कल-
बाद रख
कल
देते.
नहीं है वो सिर्फ कल के लिए हम
नहीं आज ही सुनेंगे.
हाँ, ठीक है
बहुत अच्छा है. कल नहीं और 4:30 बजे के बाद भी सुनेंगे. इसलिए इस चक्कर में मत रहिएगा कि आपको नहीं सुनेंगे. ठीक है, इनका तो सारा लिखा दिया. अब आपका देखिए. आपका कौन सा जजमेंट है आप दिए नहीं?
फिर दिए सारे दिए
MM कासिम का हम दे दिए हैं
सारे दिए
जो उस पे साइट हुआ है.
हाँ.
क्या हमने
इसमें क्या वोट किया?
इसमें वोट किया था उसका एक जो सेक्शन 11C का जो इंटरप्रिटेशन था उसके बेसिस पर अपीलेट कोर्ट इसको डिसमिस कर दिया था. दैट वाज एंटायरली डिफरेंट केस. समवन वाज देयर सूट प्रॉपर्टी वाज
ये
रिक्वायर्ड
तो
फॉर.
ये हुआ कि जो आपको एप्लीकेबल नहीं है.
हाँ
कोई ऐसा चीज है जो आपके ऊपर एप्लीकेबल है?
जो नॉन एग्जामिनेशन ऑफ द ओनर उसके ऊपर में है 1999 वॉल्यूम 6 SCC पेज 540.
बताइए. 1999
99 वॉल्यूम 6 सुप्रीम कोर्ट पेज 540
पैरा नंबर
पैरा 9. लॉर्ड
दिखाइए सर. The learned counsel has placed the judgment passed by the Honorable Supreme Court reported in bracket 1981 bracket 3 SCC 36 within bracket M.N. Qasim versus Manohar Lal Sharma, and has submitted that the state judgment has no applicability to the facts and circumstances of this case, and the learned first appellate court has wrongly placed reliance on the state judgment. He has further relied upon the judgment passed by the Honorable Supreme Court reported in bracket 1999, volume 6, SCC 540, and has referred to paragraph 9 of the state judgment to submit that non-examination of the wife of
mother of the plaintiff.
Of the mother of the plaintiff and wife of the
Late Anil Kar.
wife of late Anil Kar was not fatal to the case.
My lord may take one more judgment if required also.
अब तो रिक्वायर्ड आपको सुप्रीम कोर्ट में ही होगा क्योंकि अभी तो आपको कोई आप प्लेस नहीं किया.
नहीं एक जजमेंट वो बोलेंगे.
नहीं.
Para 22 also. Single bench of the Patna High Court.
The learned counsel has also relied upon the judgment passed by Honorable Patna High Court, reported in 1987 SCC on line Patna 186, para number
Para number 22.
para 22. To submit that non-examination of the mother of the plaintiff had no bearing in the matter. The learned counsel submits that the plaintiff, being the co-owner of the suit property, was seeking eviction for the purposes of running a shop for his son. क्या नाम था बेटा का? बेटा का नाम
Amit Kar.
अमित का. चलिए आप आइए.
My lord, just my lord has allowed me to mention before recess, my lord. I have went to Mrs. Manjushri's prayer. She has to report to Mr. Layak. Mr. Layak has ousted me from his chamber, my lord, and he has used so derogatory language against me and my late father who passed away on 4th, my lord. I have all the recordings, my lord, and I have annexed the WhatsApp chat, my lord. It was so derogatory for me. I'm begging for consent. He's using derogatory. He ousted me just like a. I don't know what I can do. I'm just giving this, my lord. Lordship,
What's the
consent
matter?
23, serial number 23. ma'am.
Serial number 23. The counsel for the appellant has mentioned this case for taking up the matter out of turn by submitting that writ for delivery of possession has already been issued on
This has been issued on my lord, 13/5/2025. It's in the
13/5/2025 and the respondent is not giving consent for hearing of this case. Post this case tomorrow? Good day. आपका substantial question of law बना हुआ है?
yes, my lord.
नोट्स बना के लेके आए.
Yes, ma'am. Only legal point is the Rule 104.
क्या आर्गुमेंट है आपका प्रेमिस?
The title suit which I have filed before filing Order 21 Rule 97 that has been pleaded in my memo of plaint. Subsequently, my lord, I have placed a petition before the trial court when it has to be stayed in light of 104. There is a recording of the trial court that the outcome of the title suit, this proceeding will be outcome subject to outcome of the title suit. Now we have won the title suit, we have won the appeal. The court ought to have not proceeded, but though it has proceeded, but now under Order 21 Rule 104, the title suit will prevail over it. Had it been case, I would have lost that case, but I would have won this case.
So
Conversely, it is
this aspect of the matter has been rejected by the learned first appellate court, or it is a subsequent event?
subsequent event. So 104 is such a rule wherein the trial court has to make himself stagnant to come the outcome of the case. So the trial court, there is an order of the trial court that it will be subject to that outcome. That is a substantial question of law.
So if there is a sale deed executed by any of the party, maybe through the power of attorney, that sale deed, execution of sale deed will be subject to the whatever. You see,
Even my lord, we tried to place this order before the trial court, but the trial court has told that there is a decree, I'll just execute it. 104, not a reason is there. I've got a certified copy of it also. I'll show it to your lordship tomorrow itself.
you see, the point is that anything which you have it in your pocket, we will not see.
No, I'm not giving.
We will just
Yes.
strictly
What-
see the
all is in
records.
the
of it.
records.
Record आया हुआ है इसका. Record आया हुआ है.
Yes.
कल सुनते हैं.
So,
कल और कोई केस 10:30 बजे लगाएं. At 10:30 first case. ठीक है? ऐसा किसी से WhatsApp चैट का इस तरह से निकाल के मत लगाना, उसको हटा दीजिए वहाँ से.
no, वो चीज हमने लगाया. That it has been denied. That's what I have, because my lord has told in the morning I should
नहीं,
not lie.
उसको ऐसा का आप बोल के उसमें अगर लिख देंगे ना that consent refused, that is sufficient. इससे ज़्यादा हमको जरूरत नहीं होती है. ठीक है? इस तरह से लगाना ठीक नहीं है. हाई कोर्ट लेवल में ऐसा नहीं होता है.
That's what
अगर आप वहाँ गए हैं और कंसेंट रिफ्यूज्ड है, आप लिख देंगे कि कंसेंट रिफ्यूज्ड है, आई विल टेक इट दैट द कंसेंट इज रिफ्यूज्ड. एट बेस्ट क्या होगा, कल आके बोलेंगे नहीं हमको कोई ऑब्जेक्शन नहीं है, यही ना बोलेंगे.
हम लोग जो सीखते हैं सीनियर्स से. He is a senior designated.
देखिए आप किसी के बारे में उनके एब्सेंस
No,
से
I'm
नहीं
not
बोलिए,
telling.
इसे
Yes.
बोलने की जरूरत नहीं है. आपका काम है बहस करना. ठीक है? कल अगर मान लीजिए वो आते हैं बोलते हैं कि नहीं, तो वी विल सी व्हाट इज टू बी डन. हमको याद है बोले थे इसमें कंसेंट होगा, नेक्स्ट स्टेट में कर देंगे. ठीक है?